why does this keep happening? So I want to offer everybody some answers as to exactly why this keeps happening and this outcome of law enforcement not being held liable criminally. Sometimes civilly, we'll see a lawsuit or a settlement, right? But we never really see a criminal charge sticking with these officers. Well, the statutes generally read like this, y'all, state and federal. Law enforcement is not deemed to be unlawful in the killing of civilians if it's deemed to be reasonably warranted, if they have reasonable fear. What does that sound like to y'all?
What does that even mean?
What does that mean, Charlotte?
Yeah, what does that mean? It's this question and this interview that has me wondering, where does the reasonable fear phrase come from? What does it mean? And why does it allow cops to kill unarmed black people and get away with it? Well, today I'm going to answer all of those questions plus more. I'm Jamal Nolan, and this is Culture Breakdown. In order to understand this reasonable claim, you have to go back to 1985 in Charlotte, North Carolina, where Ebony and I both grew up coincidentally. On the west side of Charlotte, North Carolina, there was a black guy named Dethrone Graham who was at home with his buddy. He asked his buddy to take him to the convenience store to get some orange juice because he was a type 1 diabetic. So Mr. Graham goes into the convenience store, he grabs his orange juice, and he sees a long line at this convenience store. So it's no longer convenient. He puts the orange juice down, runs out of the store, hops in the car, and they drive away. At the same time, there was a police officer across the street watching the entire event. What this police officer observed was a guy run into the store, run out of the store, hop into a vehicle that was awaiting him, and then go pull off. So the police officer trailed him. He pulled him over on West Boulevard. He grabs the license of the driver while the driver is telling him that Mr. Graham is a type 1 diabetic and he needs some orange juice immediately. The police officer goes back to his vehicle to find out if there was some kind of crime committed at the convenience store. While the police officer is in his car, Mr. Graham gets out of the passenger side. He runs around the car once or twice, and then he passes out on the ground and he starts going into shock. He's having an insulin shot. It's basically, for him, it was basically like a seizure. At this time, 4 of the officers arrived. They handcuffed Mr. Graham while he was passed out. During this entire exchange, he was passed out. He was waking up in and out of a coma, basically. And he was telling them, I am a diabetic. I need some orange juice. One of the cops was like, he's not diabetic. He's just drunk. So they proceeded to pick him up by his handcuffs, slam him on the car, hit his head on the car. He had cuts on his hands. He had hand injuries. He had shoulder injuries. And he also had a broken foot. The cops pretty much roughed him up pretty bad. Once they found out that nothing occurred at the convenience store, there was no crime, there was no robbery, there was no theft, 4 people grabbed him by the arms, 1 by each arm, 1 by each leg, and they threw him in the back of a cop car. They took him home, laid him out in front of his yard, took the handcuffs off, and drove away. So naturally, he wants to sue. What happened that day in Charlotte eventually becomes one of the most important Supreme Court cases when it comes to policing. Every time someone is murdered by a cop, this case is essentially the primary foundation to any argument. He takes the police to trial and he loses because he can't prove malice in their heart or bad intentions. Long story short, 5 years later, the case eventually goes to the Supreme Court. So now we're in 1989. Basically, they're asking the court to judge reasonableness. Under the circumstances, would a reasonable person do this? So while at the Supreme Court, they're basically arguing objectivity, bad intention versus no intention. You can basically sum up the case like this. The cops had no reason to use excessive force on a diabetic man going into shock. On the flip side, it's the cops saying, clearly this man is drunk. He's resisting arrest. We have every right to use excessive force. While they are basically arguing semantics, something interesting happens. The only black person on the court speaks up, Thurgood Marshall. And he asks a very interesting question.
What reason was there for handcuffing a diabetic in a coma?
Well, at the time, the officers didn't know that he was a diabetic in a coma.
What was he doing that was so violent that he had to be handcuffed?
You have to go back one step even before that. Officer Connor saw a petitioner act in a very suspicious and unusual manner. Hurry into a convenience store. No, it wasn't clear. He saw him hurry into a convenience store.
Well, what did he do that was violent?
Excuse me?
What did he do that was violent?
Mr. Berry's
anybody?
testimony, as petitioner's own witness, said that petitioner was throwing his hands around, that Berry had asked for Officer Connor's help.
What was he doing? I'm talking about before they put the handcuffs on him. What was he doing before they tried to put the handcuffs on him?
He was acting in a very bizarre manner. He ran out of the car, circled around it twice, and then sat down. The district court...
Was that threatening anybody? Did he strike anybody?
Well, the officers didn't have to wait until he was...
Did he strike anybody?
I don't believe the record indicates that he struck anybody.
Did he threaten to strike anybody?
He was acting in an unpredictable and potentially dangerous manner.
Can you answer? Did he threaten to strike anybody?
He did not overtly threaten to strike anyone.
Did he have a weapon of any kind?
The record doesn't indicate, I don't believe.
The record didn't show he had a weapon of any kind?
That's correct, but the record...
Why was he handcuffed?
The record shows that he was properly stopped as a suspect for a criminal investigation, that he was acting suspiciously, that he was acting in a bizarre manner. Indeed, even after he was handcuffed and the officers went to put him in the car, the undisputed record shows that he was vigorously fighting and kicking.
Well, shouldn't a diabetic object to being arrested rather than given treatment?
He wasn't arrested. He was never arrested.
Why was he handcuffed?
He was handcuffed because the officers were concerned that he was a criminal suspect. He was acting in a very unusual and erratic way. He was throwing his hands around. Indeed, the district court stated from the record that he was handcuffed in part to protect himself as well as the officers and others.
To protect himself?
That's the district court summarized the record as indicating that. That's correct. Now,
may I differ with that conclusion?
The court rules unanimously in Graham's favor, basically stating the court should have to look at this from a reasonable person's perspective when examining these type of cases. Graham goes back to court and he loses again. And the reason why he loses is because the ruling that was supposed to work in the victim's favor is now heavily in the police officer's favor. So the jurors are asked to look at the case from a reasonable officer's perspective. What would that person do if they was reasonable in that split second? They're not to look at this case in 20/20 hindsight. They're supposed to put themselves in the moment, at the scene, in that police shoes, and how would a person react in that split second moment? That's how this objectively reasonableness is brought about. And now it doesn't work in the victim's favor, it works in the cops' favors. And cops literally use this to their benefit and for their protection. They even train on this. They show clips and they learn how to operate within the confines of this law. To me, it's basically like giving them the answers to the test. They already know what the law says, so they feel like they have the right to get away with things because it was reasonable. So that's how you have situations where cops say he was reaching for his gun and I shot him. And it turns out that person didn't have a gun. They just had a wallet. Guess what? It doesn't matter. In that perspective, what would a reasonable person do if they were afraid and they saw somebody reaching for something? So a lot of times in these cases, the jurors side with the police officers. They are only looking at it from that split-second decision and not the totality of the situation and not in 20/20 hindsight. Was this officer correct in his actions in that moment? So Ebony is correct.
It's deemed to be reasonably warranted if they have reasonable fear. What does that sound like to
what
y'all?
Does that even mean?
What does that mean, Charlotte? This is
yeah.
what we call a nothing sandwich, right? Mm-hmm. That gives law enforcement this much latitude, wide open, a football field of latitude as to around what they think. Discretion is a fancy word for their judgment.
So
that's
you
all
could
that
say,
means.
He moved his arm and I felt like he was reaching for a
scared.
weapon.
Correct. I was scared. I was in fear, right? So, and listen, I want to be fair, right? I understand that these officers sign up for an inherently dangerous job, right? Every day they put their lives on the line. They go out their homes. They leave their wives and children as well. They don't know if they're going to come back. And I understand that. It's important to make that point, y'all, because that's why the laws are written so favorably to their actions.
I promise them they're not. We're more scared of them than they could ever be of us.
Sure, and that's definitely the other side of that argument, Charlamagne. And this is what I'm getting to. Until the statutes read differently, y'all, until the laws have some real meat on the bones, have some language in there that talks about what that discretion has to look like, that talks about this type of action when there's not a weapon, when there's not, as you say, Angela, in your example, an aggressive, overt action from, the victim in this case, that's not deemed to be justifiable.
What do you think the language should look like?
The language needs to look a little something like this. This is just a little off the cuff, right? But it needs to say something like this. Law enforcement killing, use of deadly force, that's the magic words, right, is unlawful and unjustified absent, we got to shift the burden of proof. So it's got to be presumed to be unjustified if and when the following criteria aren't met. So there's no weapon, or the weapon's not armed, or the weapon wasn't in reasonable reach of the person. That's a shift in presumption, y'all. Right now, the language typically reads, the officer is justified unless. See how that's different?
Yeah.
There's a presumption of justification by any and all actions of these officers unless these special circumstances are met. And y'all tell me the cases where the special circumstances have been met. They're hardly ever met.
Yeah.
The laws must be changed. The language in the laws must be changed because the language is the loophole in which police officers are allowed to go free. Now, the good news is, in the case of George Floyd, nobody appears to think that this was reasonable behavior. The officer's behavior is exactly the opposite of reasonable. So I pray for change in the law, and I also pray for justice for George Floyd.